Hello, good morning. Good morning, everyone. Thank you for joining us in our webinar, Immigration Planning for Families Relocating to and Settling in the United Kingdom. My name is Peju Ojemuyiwa, and I'll be talking us through the various pathways, means to do this successfully. It is one thing to relocate, but it's another thing to do it successfully. And that's our goal here in Michelle Bell today, to make sure that we give you the information and everything that is needed to ensure that if you're planning to relocate with your family to the United Kingdom, you do it well, you do it all the information that would allow you to make informed decisions. And most importantly, you'll be able to settle in the UK without any hitches to your journey. So our goal here today is to protect your family's journey from relocation and family visas, ultimately to settlement in the United Kingdom, not just one visa at a time. So I'll just sort of go straight away into about Michelle Bell. Some of you may know have heard about us before. Some of you may have heard about us before. So Michelle Bell is a UK's, as you've seen there, immigration and advisory company, and we help individuals and families, professionals and businesses achieve their immigration and relocation goals. So individuals want to relocate. Sometimes businesses are also looking for international talent, and they need to know how to get them to the United Kingdom. We are the bridge between the law and ensuring that, whether it's the business or the individuals, they all reach their goals compliantly. And we do this with certified expertise, but more importantly, we also ensure that we provide personalized end-to-end service. So from where we stand, no one migration journey is the same. Everyone is treated as an individual. There are cases that are looked at specifically, whilst there might be very common visas that people are trying to apply for, but their starting point is always different just because their circumstances are unique. So we take all of this into consideration in Michelle Bell, and that's what we do to make sure that the service we give is bordered on integrity, consistency in service, consistency in how we approach, and definitely we ensure that we're servicing you, our clients. So how can we help, and how we normally sort of help individuals? I think I've sort of spoken about this just now. We work with individuals, towards their own sort of settlement. Some want to come for a short time, some want to come, actually for a longer time as well. Regardless, of that, Michelle Bell ensures that we meet your goals. So we help with families and settlement. We help with work sponsorship and compliance. We also help with, again, relocation and global mobility, where individuals are thinking, look, we want to move. What is our move strategy? So we actually start with that. And of course, we have our long-term settlement strategy, which means everything we do from the get-go is focused on the end goal from the very beginning. And also, just a little bit more about myself. I am, the founder of Michelle Bell Immigration Solutions. I've been practicing immigration at the highest level since 2010. So that's almost 16 years, but registered since 2008. And I and my team, we've assisted countless, individuals and families. These are thousands and thousands since 2008. So, be able to sort of settle in the UK successfully. We're IAA regulated, of course, so our advice is regulated, and we are regulated at the highest level, meaning that, we can take every case from the beginning to the very end. And when I say the very end, sometimes it's just because the UKVI themselves make some decisions that are maybe inaccurate or maybe unlawful. And again, if we have to challenge those, we have the capacity to do so. So I've helped families, professionals, and founders. Some people want to bring their businesses to the United Kingdom. They're thinking, look, how do I access Europe? Or maybe that part of their, growth plan is to now have, to have a presence in Europe. And UK might be where they're thinking, look, this is where I want to set up my business, in which case we've been able to assist lots of founders navigate the UK immigration to be able to expand their business, use that to be able to sort of settle as well in the United Kingdom, should that be their goal. And of course, relocation and settlement, as I've said, to ensure that individuals and families get this with clarity and confidence. So that's our goal. Our clients are never confused about what we are doing. They're actually empowered. They understand the journey they're working, because we take them through everything that we're doing. I've talked about some of the things that Michelle Bell does, but this is my area of focus, which is really not just one visa at a time, but looking at the holistic plan of the individual from the very get-go, and to ensure that we reach that goal effectively with the strategies and solutions we've built in from the very beginning when individuals sort of approach me or approach our company. And that's the our basis of operation as as a company, and myself sort of working with individuals. So for those who I have not met before, I know that many of you can see me, I probably can see you, but again, I'd like to welcome you to this webinar. Please do start dropping any questions that you have in the chat box, or write it down at the end of my presentation, which is pretty much maybe about just 20 minutes talking about different routes. I'm not going to be delving too in depth into any one particular area, just because I'm sure that there are many people with perhaps different areas that you're thinking about, but I'll just talk about all the avenues that are potentially available. Do ensure that all your questions are are written down, and you'd have the floor to speak and ask your question live, or you can we can actually read them out once we see that they've been written down for us. So I'll definitely ensure I take all questions today and demystify UK immigration rules for you. Okay, so just to go directly now into the the webinar for today, and just start talking about what we want to do. So why does family relocation matter, and why does getting it right matter? I think that's really crucial. Why does getting it right matter, which is is a very important thing. It becomes it's quite heartbreaking sometimes when families come into the United Kingdom, and when it's time for an extension, or when it's time for something, someone now realizes that, oops, actually my family cannot extend with me. They came with me as a student, but now that I'm switching into maybe skilled worker, or we're trying to move on to the next path in our United Kingdom, all of a sudden they cannot move with me, and that becomes a bit of a dilemma. These are the things that we want to fix, because I think if there's been strategic planning from the get-go, people are not going to be taken by surprise. They would also know exactly what they need to do. So why does this matter at this time? Why are we speaking about it specifically in this webinar? Is because behind every family refusal, there is usually a fixable planning gap. Okay, so behind every family refusal, there's a fixable planning gap. So a gap has occurred from the very beginning before we see that refusal. So what we're seeing, and what we've continued to see, but is heightened in the last few years, and more heightened in the last few months for sure, just because of the direction the UK is going itself. One of the things I say is UK and every company or every country would always have its own plans. It would always have its own agenda. It would change things. It would move things around. The families that have a strategy from the beginning would not be caught out by those. And that's what I meant by there's usually a fixable planning gap behind every refusal, behind every family migration that has suddenly gone out of plan, or they look like, oh, actually we started it, we can't proceed. There's usually a planning gap and something like that. So we want to talk about those. We want to say, how do you fix that? So families are being frustrated, they're being separated, they're refused, or watching their reunion plans collapse. Most often this is because of the wrong immigration strategy, not bad luck. Okay, and one of the reasons I'm talking about not bad luck is because the UK visas and immigration, they don't really know anyone personally. Okay, they don't know you personally. All they know is all the information that has been packaged and put in front of them. And if that information does not make sense, if that information does not align with policy, they will refuse it. If that information, even if it looks like it aligns with policy, but it doesn't stack up. Sometimes there are ways that you tell a story and it doesn't have that continuity. It doesn't stack up. Again, they will pick that out, and then that impacts on the family. So it's more a wrong immigration strategy, not bad luck. Don't think that the UKVI is after you. They're really not. The law is there for a thing, which is to ensure that none of them can make decisions just because they like to make decisions. None of them can just refuse your visa application or refuse to allow you to come in just because they feel like it. They don't have that power. The law is there to guide them. They work with guidance, they work with guidelines, and they work with law and principles. Our own what we encourage families to do is to ensure that they understand what law underpins their goals from the very beginning, and then work with that. And that's what we do in Michelle Bell. So recent rule changes, I think I've mentioned that. Again, I've hit families hard. Higher income threshold for those who are family members of British or settled citizens, dependent restrictions on on care. So dependents whose family members are on care routes obviously there's restrictions on those that we know that their dependents can't come in, or even those that were already in with them on maybe student visas or graduate visas before, and they're now, switching to care. They're having that same challenge as well. And they're thinking, look, what's happening to my family? It's a bit distressing when we sort of speak with people and their family is not settled, their family is not, they're in the UK with them, but their families do not have the legal state to stay in this moment in time. Again, there's, a gap in strategy, not because, they didn't see these things coming. They knew that this law was there. There's a gap in strategy. How do I move from point A to point B to ensure my dependents are okay? Same with the graduate routes as well. Graduate routes has some good news that came in about 2 weeks ago. I'll just drop that as I go on. And of course, there's a settlement system that, is having, problems. It's just going influx at the moment. So that's the reason why this matters at this time. Of course, the result of all this is delayed settlement. Okay. When people cannot continue on the path that they are, their visa, is pressured, is sometimes cancelled. They get out of leave because they're moving from one visa to another. Some things that they've done systemically in the UK at the moment is everyone maybe sort of applying for fee waivers for the leave to remain and not really understanding the implications of that. And I think in my session today, I'm also going to be talking about some of the examples we've seen with those who've gone to fee waiver that was refused and they continue to assume they had, continuous legal residence, and that impacted them significantly. So we've seen dependent visa challenges, sponsorship challenges, of course, and the real uncertainty about what to do next. And this is one of the reasons why we want to talk about planning from the very beginning. So wherever you are, whether you're thinking of relocating your family, whether you're actually in the UK at the moment and your family settlement, moving to settlement is under pressure because of some of these things that I'm saying, then you'll find some wisdom nuggets today. Hopefully you want to discuss with us what your personal circumstances are, and then we can start working that journey with you from now. But the good news is that most of these situations, so I've painted all of these scenarios that is happening, and I don't even need to speak about it a lot. All you have to do is you just scroll on your social media and you'll see quite a lot of sort of migrant channels speaking about these things and migrants speaking about their journey. So, but the good news is that most of these situations are avoidable with the right planning. So for those who are still planning, they're avoidable. You don't want to get into this situation and planning early enough. For those who are already in a pressure situation, again, having the right strategy, how do I get out of it, is still a conversation that you can always start to have even from now. So it's never too late to start from now. Today's goal is to give you a clear, calm plan for your family's route to settlement before problems arise, ideally. But even if already, there are pressures already happening, again, today is still the right day to start moving forward in that process. So what you're going to live with is 5 things every relocating family should understand. Okay, I'm going to talk about the family route map, which visa routes fits your own family situation. I've talked about, individual, we plan with individuals, not just thinking about you as a collective. Regardless of the common visas, you're an individual, your family's plan, your relocation goal deserves that personalized guidance. And we're going to talk about the traps that is currently occurring by visa type so that people understand that. I've spoken about it very briefly: care, student, and graduate visa pitfalls, meeting the requirements, the 29K income rule for partners of settled and British citizens, and what are the requirements for partners and dependents of those on work or business routes as well. They all have their requirements as well. We'll touch on those very briefly. We're going to talk about the road to settlement, 5-year versus 10-year routes, what's changing, and finally, your family game plan. You must have a game plan for your family, how to plan the journey with confidence. That's really important. So again, starting with the UK family route map. This is really what it looks like when we're talking about family visas, dependent visas. And the question, when you look at the first question you should be asking when you're thinking of relocating is, which route fits my family situation? That is so crucial. That is a question you should be asking. Which route fits my family situation? Which route fits the goal that we want ultimately? All of this will take into consideration your background, the status of your spouse. Are they a UK citizen, a settled citizen, or they are in the UK on a work permit or some other sort of migrant visa? All of this will determine. So the first 3 at the top there, spouse or partner, fiance, parent of a child in the UK, and also the family reunion. The 5th one is all really about British and settled citizens, who their families are coming to join them. So the parent of a British child who is studying in the UK or is resident in the UK can come to join them. The partner of a British citizen can come to join them. Most important, is the financial requirement of at least £29,000 per annum that the partner has to earn. The British partner has to earn, especially if the British partner or the spouse is coming from outside of the United Kingdom. If the spouse is in the United Kingdom, then the earnings could actually be either the British partner or the dependent, or it could be a joint, income. So it all depends on the status, and that depends on how you're going to evidence that financial requirement. All of this, of course, depends on ensuring that you are able to prove that your relationship is genuine and subsisting. So regardless of whether you are coming as a spouse of or dependent of a British or settled person, or the spouse of someone on a work visa or someone on a migrant visa, there are certain eligibility criteria that is common to all. And that is, for example, one of those is your relationship must be genuine, your relationship must be subsisting, it must be real, and you must have documents to back up the fact that your relationship is genuine and subsisting. So I'm only focusing on here in this slide, I'm only focusing on the slight differences that you need to focus on. So the family members of migrants do not necessarily need to be demonstrating £29,000 in a financial requirement as such, because they don't have that to meet. There are other requirements they must meet, being the family members of migrants and those on sort of maybe skilled worker visas or those on innovator founder visas. They have certain other requirements. But the genuine relationship requirement, the fact that there must be able to be evidence and to show that actually we are married. And it's not just with, a marriage certificate. So a marriage certificate is one thing, but beyond the marriage certificate, there'll be evidence that you are actually sort of living together in a relationship akin to a marriage, for example. And this cuts across board. And if you're not living together, you must be able to give evidence why. Perhaps work, one of you has meant to travel away for work or things like that. And then your family can apply. Also, there's a child dependent visa, which is children that want to join their family in the United Kingdom or their parent. This slightly, again, there's some slight differences depending on whether the family is a British or settled citizen, or actually their parents are actually economic skilled migrants in the United Kingdom. But most common background to this is that the child must be under 18 to be considered as a child dependent visa trying to join their parents. Very crucial. And obviously you must be able to evidence that the child is yours and demonstrate that you have ongoing genuine parental responsibility for the child. So I'm going to move very quickly to the sixth one there, which is dependence on work and study routes, which are the partners and children attached to skilled worker visa, economic migrants, global talent, eligible skilled worker visas. Those that, when eligible skilled worker visas, you know that means not all student visas. For example, holders can bring their family to the United Kingdom. That's why it's eligible student visa, and where the route allows it. So the dependence on work and study routes can actually come in as well. So you look at, where do I fit in all of this? And then you can come into the United Kingdom with your family, ensuring that you meet all of the eligibility criteria. Very important, that is specific to your routes. Now, outcome 2 that we are looking at is for those who are already in the UK. And I spoke about traps by visa type here, because someone can already be, in the United Kingdom and their family had come with them, perhaps on their student visa, because it was a permitted, route for them to do so. And then they're thinking, look, I'm now, coming to the end of my study, I'm coming to the end of my, graduate visa, for example, and I want to switch to skilled worker visa. Again, if they're switching to health and care worker visa, put that in red, as you can see. It doesn't allow dependents since 11th of March 2024. So whether you're in the UK already with your family that came with you as students, they would not be able to transition with you if you transition to a health and care worker visa. So that would create a bit of pressure for you, for your family, because you're going to be thinking, what will my family be doing if I get a job on the health and care worker visa? So that's something that is really important. Of course, there are exceptions to this. There are some exemptions. Some people are exempted from, this ban of families dependents of health and care worker visas. And one of the exemptions is if the individual has held the health and care worker visa before March 2024, when the rule came in. So if the individual has held that, then they are exempted from the fact that their families can, switch with them regardless of whenever they're switching into, sort of, health and care. So their families can always sort of switch with them. That'll be an exemption. Children born in the UK as well are exempted from this. They'll be able to apply because they are born in the UK. Most important thing is that their parents must have lived in the United Kingdom. And this is where health and care worker visas must plan properly. Because the key issue is that, both parents must have valid leave at the time when they are applying for the student, so for the child. So there has to be enough planning around the family circumstance to be able to utilize what the rule allows and what the exemption allows properly. Of course, there's also, the student visas, again, where dependents have been sort of banned since 2024 for most, almost all courses, except, the, postgraduate research and, some other that can bring their families now. Study time does not count towards settlement for those who are thinking about settlement. And again, the plan would be to switch away. If you're planning to settle and not go back after, study, your plan will be to switch away into, a settling route before your course ends. You're thinking, look, before your course ends, you're already thinking, where am I going? So it doesn't catch you unawares. And rather than having one plan, you're meant to have at least 2 or 3 plans, just in the event that one doesn't work. You have the other ones that you can pivot to that allows you to move towards settlement. But of course, if settlement is not a plan and you're thinking, look, after my study, I want to go back, then for sure, you don't need to think about all of these plans. But I guess you're here because settlement is your plan. So graduate visas, again, does not lead to settlement. The time spent on it does not count to ILR. So if you go from student to graduate visa, you spent maybe 18 months on student, you go to graduate visa of about 2 years. That is 3.5 years you've spent in the United Kingdom. That does not lead to us, does not count towards ILR on its own, except you're trying to bolt it with a 10-year pathway, to settlement. And, that is, but on its own, it doesn't lead to settlement. So again, there's a new law, I think, that would come into place from the 3rd of August, 2026, which is a child born in the UK during the graduate leave can now be added as a dependent. So while a graduate visa holder cannot bring their dependents from outside of the UK who did not apply to come with them initially, their child born in the UK will now be able to be added in line with their leave. Almost the same thing like the exemption I did talk about on the health and care worker visa. But still, no new overseas dependents, only those already on as a dependent on their student visas that came with them will be able to allow for that. Again, it's currently 2 years. The Home Office is planning to change this to 18 months, to reduce this to 18 months from January 2027. So something to keep an eye on. Currently, 2 years is not even enough for graduates to plan and switch to a skilled worker route or to any other route, that they want towards settlement. Imagine if that is shrunk now to 18 months. So that is clearly what's going to happen. We've known this from the beginning of this year. So I would expect that graduate visa holders are planning significantly not to be caught out with these new changes coming in as well. And of course, if they're planning to switch and to settle, they must do this in good time with a good strategy in place. So I've talked about the £29,000 income rule. Again, this is for families of settled citizens and what their settled family needs to have. There are various ways of meeting the requirements. I'm not going to speak too much about this. Various ways of meeting the requirements, whether it's employment, and they must demonstrate that with pay slips of usually the last 6 months, where they must have been with the employer in the last 6 months. If they haven't been with the same employer in the last 6 months, then there are other ways that they would need to combine and meet the requirements. If they are thinking of cash savings, then they've got to have at least £88,500 in their account held for at least 6 months. It can be in one savings alone or a combination of sort of savings account, but the duration must be the same that we're using in the last 6 months before applying within the 6 months period, and it can go lower than this amount if they're using cash savings. And of course, it could also be a director or self-employed. Again, stricter documentation here because you have to demonstrate income through your company and also income in the company, so a lot of company accounts and things. And people can also blend the income and the savings and permitted sources. So again, we can assist with this, but again, the financial requirement can be one of the biggest cause of family visa refusals. Hence, I just thought I'll touch on this for those that are actually going to be thinking of migrating or coming to settle on the basis of their UK family member. And so who counts as a dependent? Very, very important here. Not everybody counts as a dependent. And this depends on which immigration route you're using as well. But under UK immigration rule, who counts as a dependent? Generally, these are your partner and your children under 18. Adult dependent relatives are a separate much harder routes is there, but adult dependent can be any of your adult family that depends on you for care and they want to come to you with you to the United Kingdom. But like I said, it's much separate, is much harder. So those are really counted as dependent under the UK immigration law. Is generally your partner, whether they are unmarried partner or you're married, and your children under 18. Very important. If your child wants to come with only you, you must be able to demonstrate sole responsibility and consent that you have the right to bring a child, but you must be able to demonstrate that you have sole responsibility. Sole responsibility, I put it in inverted commas because it does have its own meaning. Just because you're the one maybe sort of paying the school fees does not mean that you have sole responsibility. So there's a narrow definition of what sole responsibility is, and you must be able to evidence that you have the right and you're the one that make decisions on the child's sort of path and future and care. Also, of course, you also have to demonstrate that you have adequate maintenance and accommodation. So there's got to be no overcrowding in the family where you're going to stay, in the accommodation where you're going to stay, and you can be housed without public funds. So if children turn 18, I think it's something to talk about, especially for economic migrants. If your children turn 18 mid-journey, maybe you started when they were 16, and by the time you're 2 years in, they are now 18, they will continue to be able to apply as your dependent until they come to settlement. So a child who turns 18 during the process sometimes can decide to go their own different way just because they are 18, but really they can continue to also extend with you. So you can plan around their age. As long as they're home with you and they're not living an independent life, they'll continue to extend with you just because they came with you from the get-go as well. So again, keeping your family on the timeline, you can look at when anyone's applying, when anyone's extending, to make sure nobody's left behind when you're thinking about settlement status, to ensure you all can apply for settlement at the same time, if that's your plan. There's some people that actually thinking of some of us will apply for settlement first because of our life circumstances. Perhaps someone has to travel a lot for work and they cannot keep in line with the residence requirement, in which case that individual or that dependent can apply for settlement later on, whilst the initial family can. But if everyone's thinking of applying at the same time, you want to make sure you're keeping them all on, looking at the timelines of everybody and applying for extensions at the same time. So children born in the UK often are granted leave in line with their parents. They are not automatically British if you are not their parent. If neither of their parents is a British citizen, but they have the right to register towards becoming citizens if they live, long enough in the UK to register as a British citizen just because they were born here. But of course, there are other things that work in their favor, where they are British born children and they have not been to anywhere else. And again, they can move towards settlement in that way as well. So the road to settlement for families that we've been discussing is years of continuous residence in the UK to indefinite leave to remain. Currently, and again as proposed, so currently for families of settled citizens, families British or settled citizens, 5 years. Parent of a child in the UK again is 5 years as well. Dependents of skilled workers is 5 years. And then, of course, there's 10 years long residence for other family routes as well. So family routes, there might be 10 years. For those that don't qualify for 5 years, maybe they don't meet the English language requirement or they don't meet the financial requirement, and they're all other human rights or private life rights that they have now been granted leave to stay in the United Kingdom. So they'll be on a 10-year pathway and get to settlement in that way. Now, there's a proposed new baseline. Earned settlement is not a thing. It's been something that's been proposed since last year. It's still in the works, to the extent that most of these 5 years you're seeing at the top here, especially for the skilled worker and their dependents, might be going to 10 years if this becomes law. So we're still watching this space. And this is one of the reasons why skilled workers must also be strategically planning as well, especially those that are very close to settlement. And if those that still have probably at the start of their journey, is something to watch. If this becomes law, the most important thing that the Home Office was saying here was that high income earners will still maintain their 5 years. So high income earners are actually those in the 40% tax bracket. Then they'll not be impacted and they can maintain their 5 years. For those who are not in a 40% bracket, they start from a 10-year end settlement and they can start deducting the 10 years by perhaps work in the community or other, things that can reduce it gradually. So watch this space if you are actually a skilled migrant and you think, what does this mean for me? If the end settlement becomes a thing, how do I ensure that I am actually, myself and my family, we're bulletproofed against whatever these rule changes might be. And you start to position yourself to ensure that if it actually becomes a thing and it becomes law, it's not going to impact us. We can all assume that it wouldn't become law. It's illegal. It's not meant to be retrospective. And we've seen a lot of migrants say those things. And, in reality, the government has been fighting against that as well. The rule was always planned around those who were already in the UK. It's those who were already in the UK, about the 2.2 million people that came in 2020, between 2022 and above, that they are trying to address with this end settlement. They have already addressed skilled migration and brought it down by making it difficult for employers to, resource internationally, by reducing the number of courts, by banning healthcare dependence, or even healthcare recruitment from outside of the UK. So that has significantly brought down the figures for them. This end settlement is really focused on those in the United Kingdom. So that's why they've been also fighting to make sure that they pass it through. We still saw, the Home Secretary try to defend this week, I think, or last week, very recently, just try to defend her position. So watch this space. My key to you is, while we are watching this space, don't just be watching. Be thinking, look, how do I strategize that in the event that it becomes a thing, it doesn't impact me, and start working towards that. Okay. So mistakes that separate families, I think, again, we're just back to that. The avoidable errors, avoidable, I use, that can cause refusal and delays, wrong routes for your situation. Just because everybody is going that way does not mean you go that way. Now, we've heard a lot of migrants saying, yes, I'm going to apply for global talent. 2 months or 3 months into their visa expiring, all of a sudden they want to apply for a global talent, and they have not built that global talent background before. There's nothing in their background that talks about you being a global talent or exceptional, talent or exceptional promise. But because everybody is saying it now, you're seeing it on social media, you're just thinking, let me just apply for that. So that's a bit of a problem, applying for a wrong route for your situation. You've got to apply for a route that actually fits your situation and moves you forward. And that's where consulting with your consultant really matters, because that way it's about you, it's about your plan, it's about the options that work for you, and you know how to navigate those options. So just pick up something just because it's what everyone's doing. Innovator founder visa is something that everyone's really talking about, but these are all business categories. And for those who cannot sort of run a business, so running a business on its own is challenging enough. But when you look at what the innovator founder did, ask of the founder, to ensure that they're able to extend at 12 months, at 24 months, they do have milestone checking. When you look at those things that, you have to meet, and the milestones you have to meet and surpass, even natural businesses that don't have a visa condition to meet struggle to meet some of these milestones. So I think you have to be clear. If you're thinking of an innovator founder visa, you have to be clear. What milestones do I have to meet at month 12? What milestone do I have to meet at month 24? And you ensure, can I realistically meet this? Even if you can't, and you're thinking, okay, I still want to get on it to get my immigration started, then you need to plan significantly, strategically, how do I meet these milestones? Some are doing it properly. So ensure that you have solid evidence, not just weak financial evidence or weak documents that would then, cause a refusal, and then you start going to appeals. If we can avoid the appeals, if we can avoid the litigation, which sometimes we would win if the Home Office have not sort of done the right thing by you or have not assessed your documents properly, but the stress of it is quite significant. So if we can avoid all of that stress for you by ensuring that from the get-go, you actually have planned properly, you have all the documents to substantiate your claims, and you're able to then submit the documents that ensure that you demonstrate you meet the eligibility requirements, suitability requirements, then you would avoid the refusals and the delays that come with administrative reviews or things like that. So if you're leaving the switch too late, this is definitely something we're seeing significantly. People are waiting until 6 months before their visa is expiring, 4 months before their visa is expiring, and then they're thinking, look, what else do I do? And that's where you make decisions out of pressure. Say, yeah, now my visa is expiring, I just need to switch somewhere. And that's why you see the main applicant perhaps then obtain a healthcare worker visa, because they just need to switch and maintain legal stay, but not thinking about, look, how does this impact on my family? Because the family now cannot switch with you. The law does not allow it. But people are hoping. So hoping and law is quite different. It creates a bit of pressure. I understand that, yes, that's what you have to do. But as long as you have an informed decision to know that this will not allow me to switch my family, the hoping and applying is a different thing. So if you apply and the Home Office grants it, which they've done before, which is why I think many people think about, we hear many stories around, oh, yes, I know a lot of people that have been granted. Now, why is mine different? Again, I've talked about there are some exemptions. You may fall outside of the exemption. Those of your friends who have been granted may have been granted in those exemptions. So know the exemptions. Do you qualify for the exemptions? If you don't, then you should know how you start planning towards if the Home Office does not grant it. What are your options? So leaving the switch too late is definitely an issue that must be addressed. And people and migrants actually start working towards their settlement earlier than later as well. Forgetting a family member, again, sort of, securing the main applicant, mistiming a child or partner sometimes can be an issue as well. Leaving someone out of status, not applying on time, inadvertently, some do that. So we've seen some people say, oh, actually, I didn't have enough money to apply for my child, and therefore, I'm waiting until later to just, join my child to my visa, and the child becomes out of leave. And because they just assume that the child becomes out of leave, the child can always be added. And there's some truth to that, because your child is a minor. Your child will never be thrown out of the UK if you are here, but it could create some timing issues with settlements and things like that. So watch that. Watch breaking your continuous residence. Ensure that you don't have unnecessary long absences of over 180 days per year if you're planning to settle in the United Kingdom. Beyond settling, if you're thinking of British citizenship, which only allows 450 days in 5 years, you want to stay significantly under that 180 days that you're even allowed for settlement as well. If British citizenship is obviously not a thing for you, and you're thinking, look, once I've got my settlement, I'm really happy with my nationality, I don't want to get a British nationality, then by all means, you can then use the maximum of the 180 days per year. But if you're thinking of British citizenship, after 12 months after the settlement, you want to watch the 180 days that you're allowed. And simply because the British citizenship, like I said, allows far fewer less days, almost half of what the continuous what the settlement gives to you. So watch that as well. Underestimating the costs, visa costs, and even the English language requirement is a thing. Underestimating the knowledge of life in the UK and not doing it on time is a thing as well. So please ensure that you are having a look on this and keeping a tab on this. Immigration IHS costs started at £200 a year. It's now £1,035 per year. So a 3-year visa for one person under a skilled migration pathway is just for IHS alone is over £3,000. So a family of 4 for a 3-year visa is about almost over £12,000 just for the IHS alone for the 3-year visa. So that's significant investment. We haven't even started talking about visa fees or legal support to ensure you get it right. So you want to make sure you get it right, partly because you are investing a lot as well in your migration pathway. It's not the time to then, for lack of planning on time, going towards different routes or routes that are not suitable for you and getting into a refusal or getting into a situation that leads you to judicial reviews or admin reviews and just sort of spending more money and time. So because you're already expending a lot of money already, you need to ensure that you're getting the right information, the right routes to make sure that you get to settlement quickly as well, if that is the plan. So your family game plan, I think I've said, make sure you plan your journey, protect your family's journey, very important. Map your route to your settlement, just like I've said before. And the key to doing that is start from where you want to end. Start from the goal. So if ILR is your goal, make sure you start planning and working backwards from it. This is one of the things I've been speaking about on my LinkedIn page. So if you're here and you're not following me on LinkedIn, please do so. My LinkedIn page is Peju or Jemiwa, and I've been talking about settlement by design. Because once you think about settlement is my goal, then you put it into the design from the very beginning, into the foundation of what you are building. Very important to do that. Align your finances to the threshold. Whatever the threshold is, if you have a threshold, align your finances. If you don't have a threshold and you don't need to demonstrate a £29,000 because you are the family member of an economic migrant, you still have a lot of costs anyway to pay to the government. I've just talked about what the IHS fees, immigration health surcharge fee is. And for those who do not know, the IHS is really the NHS fees, access to medical support while you're on a migrant visa. So again, align your finances, plan the switch in good time, plan for the switch in good time. So if those on graduate visas, let me just quickly pause here. The fact that your graduate visa allows 2 years does not mean you stay 2 years on it. Switch on time, simply because graduate visa does not lead to settlement. The rules keep changing. So you don't want to wait until the rules change on you as well. Okay. So try to start switching on time if you need to switch. Don't wait until you're under pressure or your route actually then experiences a problem. Try to keep all your family in one timeline if possible, just to make things easy when you want to get to settlement. Ensure that people don't drift into out of status as much as possible, because it then can take something that is an application that could otherwise have been simple into a bit of a complex, status. Not always the case, but again, that can happen. So you just want to prevent it if you can by watching those timelines and making sure nobody is out of status at any particular point in time. Protect your continuous residence. I think I've talked a lot about that, so I won't speak too much about it, but that's something to watch. Your 180-day rule, make sure that you don't go over that. And of course, this one I want to just talk about a little bit. Get specialist input early. Get specialist input early. Consultations, if the cost of a consultation is so minute compared to what happens when your settlement plans, go belly up and, a spanner gets into the works. So ensure you get consultation early. The cheapest time to fix any family immigration plan is before you apply, not after a refusal. When a refusal comes in, it just gets worse from there, because now we're trying to retrospectively fix issues that shouldn't be there, fix conversations that shouldn't have happened, or the errors that shouldn't have happened. Someone said, oh, I meant to say no, and then I just said yes. We had this last week. We've had this, in the last 4 months, and all of a sudden a family member cannot come and see another one in the UK just because they have, imputed the wrong information inadvertently, they said, onto the form, or because somebody else was completing it for them who didn't have the right information, or because they just didn't know the right routes for them and they've gone on one. So the cheapest time to fix a family immigration plan is before you apply. I always say a consultation is a diagnostic moment. Nobody goes to a doctor and you're telling the doctor, just start giving me medication, just start treating me. We need to know what you're treating me for. We need to know what we're diagnosing for. We need to say, what is your immigration plan? Why do you need an innovator founder visa? Actually, global talent might be better for you based on the background that you've shown me. Or actually, you don't even qualify for both backgrounds, but since you said that you have about 12 months before you want to relocate, you could start to build your innovator founder plan now. Or actually, you're actually qualified to come in and build your business here because you run a business already. You could look at a global business mobility. Once we understand your background, we understand your plans, we can then map the solutions for you in an order of, what's the most suitable one, A, B, C, in order of, your eligibility and suitability. You have options and you can decide that this is my most suitable one. These are my backup plans. So the cheapest time to fix a family immigration plan, I'm just repeating this, is before you apply, not after a refusal. So a key takeaway just before I round up is plan early. Plan early, keep your family together. Most separations that we're seeing, most refusals are avoidable with the right strategy and the right, planning on time, and the right immigration team on your side, of course. Map the route to your family. The right route for your immigration is the first and the most important decision. Just because Mr. A and Mr. B and all of your friends have gone through this route does not necessarily mean that that's the right one for you. Your background is important. Your journey is unique, and we can determine that. Mind the visa type gaps, traps, which I've also spoken about as well. But if you have to take one of these, because again, it's the only choice available to you, perhaps because your immigration route is already under pressure, we understand that, but you need to also still be working out your settlement plans from there as well. If you plan to switch early, you might be able to avoid these traps. But if you're already in it, the question is, how do you come out of it as well? Very important decisions. And this is where a consultation is really important. Let's talk about it. Let's talk about what are your solutions. How do we continue to move you forward towards settlement? Very important. Get your evidence right. If you are a family member of a British citizen or settled person, we've talked about the financial requirement. Regardless of meeting the financial requirement, if your documents are not telling the same story, if your documents are not evidencing that you meet the requirements, you will be refused. Okay, so like I did mention, there's no bad luck and there's no luck. If you do not submit evidence, you will be refused. The Home Office may ask you, they are not obliged to, they may ask you for additional documents if you have sent some documents and it looks as if some were missing. But if you don't evidence substantially that you meet the requirements, it will be refused. So this is very important. And most importantly, build settlement by design. Aim at settlement from day one. So when you're planning to relocate to the UK and you have a business and you're thinking, I want to bring my business to the United Kingdom, and you're thinking of settlement, aim for settlement from day one. Design the entire journey, not just one visa at a time. Not just, oh, I'm just going to get this visa and then I'll work it out the next. I'm just going to get this visa. And you're not thinking, what if this visa comes under pressure? So design your whole journey from the jump and get specialist input from the very beginning. And that is where Michelle Bell comes in. We have our journey together product that helps migrants to say, you don't need to walk that journey alone. We're there with you. As a member of our journey together, you can book consultations for free as a member of our journey together. And if you have to initiate any services from our Journey Together platform, again, you're going to be getting significant discounts just because you're a member of that platform. And we know your journey and we're working that journey with you. Regardless, we also have our consultation service that you can take advantage of if you're thinking of a one-off support and you don't need ongoing support initially. Again, you can check in with us with consultations at any time that you need to make significant decisions on your planning as well. And we'll be able to discuss with you and know what you want to do and be able to support you with your immigration plan, as we have done with very, very many families. Looking on our website, looking on our Google review, you'd see a lot of testimonials from individuals who are really just telling, the support they've received, what this has meant for their settlement journey in their own voice. I mean, just yesterday, I ended yesterday with a very fantastic, sort of news from just someone that I've been working with and just speaking with for, the last sort of over 2 years. And just hearing the person say, look, I've gained confidence. I understand my migration journey, that it is actually mine. It's not the UK government's. It's not your employers. So they shouldn't really be dictating whether your migration journey works or it doesn't work. It is your journey and you have to be in the driving seat and say, look, what does this mean for me? Know the rules, know the information, make informed decisions. Most economic migrants are very skilled migrants. In fact, that's why it's called skilled worker visa. Global talent, innovator founders. So you're skilled and you bring in a lot of skill into your work, into your business, a lot of planning, a lot of risk management. Why are you not doing the same with your migration plan? Why is that left to chance? And that's what has been the challenge that has impacted on family migration. That's what has been a challenge that has made sure that people's family migration and their migration plan as well has continued to be under pressure. But if you start planning early, owning in on all the skills, all the expertise, all the experience that you have as a migrant, supported by an immigration company and strategists like ourselves, then you're able to meet your goals seamlessly and, you de-risk and demystify all immigration rules. Someone says, if a spouse or family visa is refused, how do you determine whether to reapply, appeal, or explore a different immigration route? Thank you so much. That's a really, really good question. So one of the things we say is when I see a refusal, and you look at the strength of the refusal first, why did they refuse it? If you've actually made a mistake yourself, so when you're talking about an appeal or challenging the Home Office, the first thing you think about is, did the Home Office make a mistake? Because that's the reason for an appeal. Appeal is saying, they made a mistake, they need to correct it. We need to bring this mistake to them, then they need to correct it. So if there's no mistake, I would always suggest a reapplication straight away, simply because a reapplication is faster than an appeal anyway. An appeal can take 6 months and more. So if you're happy to continue, 6 months and more can potentially keep the family apart for that duration of the appeal. So if you must go for appeal, make sure you're going for appeal because you really have a genuine reason to appeal. The Home Office have made a wrong decision. They didn't consider your family circumstances properly, and they haven't done what they should do. Then an appeal is necessary. If you are in the United Kingdom and maybe you are applying to switch into a family visa, and the appeal would not necessarily keep you apart because one person you're both in the UK, one person is not in another country. Potentially, you can look at the appeal. If again, the most important thing is there a valid reason that the appeal is necessary? Did they make a mistake? Did they not do what they were meant to do? So a mistake is not just the fact that they refused you illegally. The refusal could have also come out of the fact that they didn't consider your family circumstance properly. So those are all the things that we look at to ensure whether you need to appeal. And then we'd advise you as well and let you know based on where you're going. Also, we ask you as well, if your spouse is outside of the UK, and it's really important for you guys to come together. Even sometimes you may have a right of appeal. You may actually have a legitimate reason for appeal, but we might ask you to think about reapplication because we are thinking about ensuring that you and your family come together quicker rather than later as well. And this happened, for example, just to give an example to a client of ours very recently who was going to, the Home Office had made a mistake on his visa application, for example. And I knew that this person would win if we were to go to admin review. But admin review is taking about 12 months. And yet this person was eligible for ILR in another 1 month. So my advice was, let's just reapply. We reapplied, we got the application through, and now we have submitted an ILR application. So sometimes we look at the individual settlement plan, and that's where we want to go. Nothing that would delay you. So that's the reason, those are things you have to consider when you're thinking about appeals or should I go that way? And of course, exploring the different immigration routes. If you feel that you don't really meet the requirement, you don't meet the eligibility requirement of the family visa, and they've refused because you don't meet the eligibility requirement, then you might think, look, are there other routes that I may want to pursue? And then you can do that. Okay. So very quickly, someone said, what happens to a dependent's immigration status when a relationship with the main visa holder breaks down? So it all depends as well. So are there children, in this relationship? And things like that. So what normally a dependent visa status is tied to the main applicant. It's tied to that relationship. That is why you've come into the UK. So the same way a skilled worker has come into the UK on the basis of the employer sponsoring them, a dependent has also come into the UK on the basis of I am a dependent on somebody's visa. So you need to understand that clearly, that the moment that relationship comes under pressure, the moment that relationship breaks down totally, then your immigration status is at risk, especially where that individual also notifies the Home Office and says, look, this person is no longer my dependent. And the Home Office could then curtail your leave to remain in the United Kingdom. So if anything like that happens to you, you want to seek an immigration advice consultation. The solutions will be dependent on each person's background. Remember, I keep saying that there are unique individuals, family circumstances, unique solutions. We want to know what has happened in that situation, are there things. So we had a situation happen to one of our clients who was on a skilled worker dependent, and the family came under pressure, his relationship broke down, but we were able to help him secure leave to remain in the United Kingdom because he had relationship with his children. We were able to help him secure that. Not everybody would get that, but again, there were family circumstances that we were able to explore the law on, and we make representations and helped him. I wouldn't say that just because you don't have children, you would not have a way to stay in the UK if you're as a dependent, if your relationship came under pressure as well. But again, the solution would be dependent on what we discuss and what we know when we come to speak with you as a person. So a consultation is really always important. But as an individual, you have the right to always apply for any other visa you qualify for and switch to other visas if your dependent visa came under pressure. Okay, so I've got another question here, quite a lot of questions towards the end. Someone says, for someone on a graduate visa with 7 months left and gave birth in the UK, what is your best plan or route for skilled worker visa? I've experienced working in the insurance back home, but currently work in care in the United Kingdom. So I did mention that part of the, if you're already working in care in the United Kingdom, part of the care route, of course, if you're a child born in the UK, is naturally part of the exemptions from not being able to add your child. I did even in my slide, I did mention around the rules that have just come in from graduate visa holders as well, where any child born in the UK can be added to their visa. The same with the healthcare visa as well. While dependents are not allowed, a child born in the UK is naturally exempt. Sometimes the Home Office, of course, tries to play a bit of tricks and say no because your spouse is in the UK and your spouse doesn't have leave. So if you're in that situation and you have a spouse in the UK and your spouse still have leave to remain, currently your leave has not all expired and your child is born in the UK and you secure that healthcare visa, you might be able to use the law to work towards your advantage to get your child to be registered. There's a law because the child is naturally exempt. So you cannot go online into the immigration rules actually and check. There's exemptions. So just check exemptions to the health and care. Children are there. If there's a bit of complication, of course, for skilled migrants because both parents must have leave in the United Kingdom for the child, normally for the child to be able to come in. However, children are exempted from this rule. Children who are born in the UK are exempted naturally from this rule. So sometimes your office might want to sort of, try to move away from it and things like that. But that's where you need legal representation to ensure that you put all the rules with your application when you're applying. Okay. Another application I've seen. Another question. Does a child who's turned 18 while in the UK as a dependent be regarded as living an independent life if they are working and earning an income while still staying with the parent? So that's interesting because children can normally sort of even earn an income even from while they are 13 and things like that. The most important thing is there's the definition of independent life. I wouldn't naturally say that just because they are working, because their work may not even be sufficient enough to sort of demonstrate that they are independent. Most children in school, I imagine that this 18-year-old child you've described is still in education, is still in full-time education, and they're probably maybe sort of working in part-time, just as most children do. So that does not mean that they are independent. The test of independence is exactly what they say. What they've said, they're still living from home. They're still dependent on the parents mostly, and they've come in as your dependent before they turned 18. Then you should then continue, or they can continue to extend in that way. You just have to make sure that they haven't formed a total independent family unit on their own. They haven't moved out and living elsewhere with somebody, or saying that I'm living a life of my own, which is what the Home Office expects, or the UK expects, when people turn 18, and they're naturally an adult immediately at that time. Okay, I think I've answered most questions. Let's see. What happens to dependent migration status if a relationship breaks down? We've talked about that. If a spouse, someone says if a spouse, family, or family visa is refused under 6131 code, which is a nursing auxiliary code, how do you determine whether to reapply, appeal, or explore a different immigration route? So the same thing, 6131 code is a temporary, it's only allowed because it's under the immigration salary list, and it's also not, dependents are no longer allowed if you're switching now, simply because it's a medium skilled role. So again, the eligibility requirement is not met, and that's why the refusal is there. That's why the refusal happens. So a reapplication, an appeal, firstly, you must know that the rules, you did not meet the eligibility requirement. Okay, so when you want to appeal, what are you appealing for? That is the most important thing. So whilst you are appealing, if I were to be your advisor, I'll be telling you, actually, be actively looking at a different immigration route that would actually allow your family, because the Home Office too want to uphold the rule of law. If they just grant to you like that, because they just want to listen to your appeal or your reapplication, just because you say my family is here, they should stay with me, it means that naturally you are changing their law. You're changing the law of the country. It means that you're saying, because you granted me, for fairness and for equality, they have to start granting to everybody else as well. So they follow the rule of law. Remember, I did mention at the beginning that the Home Office caseworkers cannot just decide to refuse you just because they like to do so. They are not, they can't do that. They are guided by the caseworker guidelines and principles. And there is a eligibility requirement, which every visa type does. So whilst you have got a visa to switch into initially, this is one of the issues that cause the family separation, because your family cannot join you because the eligibility requirement for this particular visa, the limitations of it, does not allow family to join you if you haven't been, on a skilled worker visa or that health and care pathway before the rules changed. So the Home Office would have been right in that circumstance. However, I did mention individual family circumstances are different. Whilst there is a rule of law that the Home Office must adhere to to ensure they are fair, to uphold the law, and to ensure they are fair to every applicant as well, there are still individual family circumstances they must consider, especially if there are children born in the UK. If they are minor children, there's something called Section 55. Every children matters. Their family circumstance might be different. There might also be other extenuating circumstances. So regardless of trying to uphold the rule of law, the Home Office must consider every family circumstance in its own unique form. So whatever circumstance you've presented, if they have not considered it, that might be the reason for an appeal. If there's a genuine extenuating circumstance they have not thought about, that they must ensure that upholding the rule of law does not inflict on human rights and Article 8 rights. Article 8 is really human rights. Okay, so if you're refusing, you would put your family into a dire human rights situation. That's something they must consider in depth before they refuse. So if such family have that and they haven't done that, that's where you want to make sure that then you can reapply, you can appeal. But whilst you're doing that, I would be saying to you and to your spouse, start exploring what other different immigration routes can eventually take you away from the pressure. In the event that the Home Office too does not back down, like I said, they will not back down easily, because for them, it's not about that individual person. It is really about upholding the rule of law, and it's also about ensuring that they are fair and equitable to everybody who's going to be applying under that same route as well. Okay, I hope that answered the question. Someone says, what about a husband who is dependent on the same graduate visa? I think we've answered that. Can he also join if you get care sponsorship and vice versa? Absolutely not. Spouses have more, issue. If you're on a graduate visa at this point in time and you get a care worker visa, 6131, your spouse would not be able to join you. because they don't meet the eligibility, because you are only going into the health and care visa after the rule change. So right now you want to be planning and having more options. What should we be doing to ensure we don't face this pressure? If the family, if this couple you've described do not also have a child born in the UK, it also makes it that much more difficult. A child born in the UK begins to make it easier because there are exemptions. Like I said, there's no exemption for spouse because they are all adults who made informed decisions. That's the way the Home Office will look at it. You made an informed decision to go into the health and care. In fact, the law says it. It's in the law that when you do this, it should have been assumed that you knew the law and you made that informed decision to apply for the health and care worker visa, knowing that your spouse will not be able to apply. So because of that, they will just refuse the spouse straight away. So I wouldn't wait and be hoping that luck would happen, that they will grant your spouse. Okay, I wouldn't wait for that. And if you don't have a choice, of course, you can apply to extend your time, extend the time while you're looking at the legal routes to switch into. But start planning right now. So if you want to book a consultation with us, please head up to, if I can just get the team to put the consultation link into how they can contact us and book. But you can also head up to our website, michelle-bell.com. And click on contact us, book a consultation with us. Please do follow me on LinkedIn. I'm sure they've dropped my LinkedIn profile. I speak a lot about this. And the reason is because I'm really passionate about migrants getting to settlement. I migrated myself in 2005 and 2006, very early 2006, the Home Office changed the law as well. It was meant to be a 4-year pathway to settlement. They wanted to move it to 5. But, the HSMP skilled worker migration that I came under, we were able to challenge that rule successfully, and I got my settlement in 4 years. And since then, or even before settlement, I've worked with a lot of migrants. We've worked with them towards getting their settlement, towards making sure their plans are theirs and they are in the driving seat. And that's what we still do. So I still speak about this, very passionate about this. Do follow me and you will get nuggets on a daily basis. Someone says, how do we, I need to go now, how about 1 more minute to go. Any other questions, you can sort of drop it to us. I'll try to address it in my post, or maybe just make a post about it and send to everyone in the community. We also have our Journey Together group on Facebook. Do join, ask questions there. We will answer all these questions for free on the group. The only thing we cannot answer for free, of course, is your own unique circumstances. We'll not be able to speak about that, but we can answer of generic questions. So I'll take the last question. This person says, what process can we follow to bring adoptive children as breed parents? So adoptive children as breed parents, there is the Home Office has, a valid adoption sort of, link, adoption process to follow where you, so just the fact that you've gone through an adoption in a different country does not necessarily mean that it meets the adoption criteria for the United Kingdom. And that's really because there's a thing called, child trafficking, different things like that. They also know that many countries don't do it right. So if you've adopted a child in the UK through the, outside of the UK through the valid means, then we have to get on the UK's approved sort of adoption, almost like people that want to relocate to the UK for sponsorship. You have to go through the approved sponsor list. If you want to be endorsed, you have to go through the approved endorsement list. It's the same thing for the adoption as well. You've done the first step, which is done it overseas. You now have to align that with the UK and get a confirmation that, okay, yeah, this is your valid adoption, and then you'll be able to apply for your child. So question is, a follow-up to the 7 months visa left with a child in the UK. So yeah, you can book a consultation if it's a specific one you want to know. But if you have a 7 months visa left with your child in the United Kingdom, your child can join you as a dependent first. Definitely, if you've just had the child in the United Kingdom, we did say that. And if you are the sole parent of the child and you go onto a health and care worker visa, the child should naturally be able to be granted with you as well. There's something with sole responsibility. Those are all exemptions. I didn't mention the exemption of the skilled worker visa or the health and care worker visa. So if you come into a consultation, perhaps you can look at your case and be able to check, look, do you qualify for this exemption, you and your child? If you don't, then we can also, like I said, nothing stops you from having alternative plans now. With 7 months, you can start to think about other skilled worker routes. How do you position yourself to make sure that, employers can, see value in sponsoring you and things like that. So thank you so much for joining this webinar today. And thank you for all of the questions. I hope that we've been able to answer as many questions. I believe I answered all the questions that are in the question and answer box. So is any other questions, or perhaps you want to build a bit more on the question you've asked and you need more clarity, book a consultation with us, and definitely I'll be able to address this in our 1-hour consultation with you to ensure that you have a plan going forward, and your stay is not under pressure, neither is that of your family. Also, we do have our journey together with where our migrant community is. It gives you access to us, almost like a consultant in your pocket. It gives you access to us on the go. You can ask questions for free. And most importantly, if you need any representation, it's significantly discounted, almost 15% or 20% discounted for you, as against when you're coming to us, just on your own. But of course, you can always come just directly. You don't need to be a member of Journey Together if you feel you don't need any consultant working with you. But for those that we work with, it gives them that peace of mind because they know that they're not walking that journey alone. They don't need to figure out the rule by themselves. Just the way you're asking questions now, they're always just sort of texting us, and then they're getting that those questions demystified, going towards their settlement goal. So until I come your way again in my next webinar, I wish you and your family a great relocation plan and a good plan towards your settlement. Remember, always think settlement by design. And when you do that, remember that that is walking the your settlement path with Michelle Bell Immigration Solutions. Thank you, everybody, and I'll see you soon next time.